Good afternoon. My name is Alina Shaltsova. I am an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about an important decision by Attorney General that came out today, a matter of MS of 2019. In that decision, Attorney General states that those intended immigrants, aliens, how they call them, who entered the United States and were placed first in expedited removal proceedings and later were transferred to regular removal proceedings are not entitled to bond anymore. And with that decision, Attorney General overturns the standing precedent from 2005. What does it mean? Well, it means basically that all or majority of the people who are going to ask for asylum in the United States at the border will be detained unless they're paroled into the United States. And parole is granted only for humanitarian or significant public benefit. That's what it means. Basically, the administration intends on detaining detaining the immigrants who are seeking asylum until their cases are fully heard, and it may take years. That's what it means. Basically, what happens is that what would happen before previously. Let's say a person comes to the border, the person does not have a visa, does not have a green card, and the person states that he or she would like to enter the United States. If the person does not have a right to come to the United States, there is no basis for admission, the person will be expeditiously removed. Sometimes it happens actually when an immigration officer at the border, CBP officer, believes that the person is going to violate the condition of the visas that they received, and issues expedited removal order 235 under Immigration and Nationality Act, section 235, right? However, if the person states that he or she is afraid of coming back home and would like to apply for asylum, then the person is detained and afforded a credible fear interview. And at least from 2005, people who passed the credible fear interview, they would be placed in different proceedings called 240 proceedings, where they can file for asylum and have a full immigration hearing in front of the judge, and they will be eligible for bond. Okay, that's very important. Bond means they post money and they get out, and during the proceedings they're out, they're not detained. So now this will be different. There is still a possibility of the person, as the decision states, to be out, but it's parole. Parole is discretion. And I can predict that that parole will be exercised in a very infrequent circumstances. So basically, I believe to deter the people from coming to the United States and seeking asylum, that's why this decision came into place, because now you will know that you will be detained potentially for years. You will be placed in immigration detention while your case is being heard. You will not be out. You will not be able to apply for employment authorization and work while you're waiting for your immigration court date. So again, very important decision came out today, April 16th, 2019, and we're going to see what's going to happen, how it's going to be actually implemented, and what the reaction is going to be shortly. Thank you.